Good morning, everyone. Welcome to Division 21 of the 4th Judicial District here in Colorado Springs. Before we call the first case this morning, it is worth noting that the court received a request for expanded media coverage in the case of the people of the state of Colorado versus Anderson Aldridge. The court has granted that request, which means that the media, in addition to its usual ability to attend the proceedings and report on this matter, has also been granted permission to record, live stream, and rebroadcast certain portions of the hearing this morning. Both the public and the media should keep in mind that the court must balance the freedom of the press with the rights of the parties to due process and a fair trial. In service of that mission, Colorado law provides that the court retains the power to curtail expanded media coverage when the needs of the case dictate. The media and the public are encouraged to view my order at the Colorado Judicial website and the website for the 4th Judicial District here in Colorado Springs. I have approved expanded media coverage only for the filing of charges portion of today's hearing. I will notify you when that portion of the hearing is complete. At such time, recording of the proceedings must cease. The media and the public are welcome to attend the remainder of the hearing, but no further recording or live streaming is allowed. For attendees who are physically present in the courtroom, you are reminded that appropriate courtroom behavior is required. Audible outbursts or other interruptive behavior is not allowed. Any violation of these orders will subject the violator to the loss of the right to attend these proceedings and/or sanctions for contempt of court. Next, I will have the parties announce their presence. We will start with the prosecution. Mr. Allen.
Thank you, Your Honor. Michael Allen, Jennifer Veman, and Reggie Short on behalf of the people of the state of Colorado.
Good morning.
Good morning.
And now for the defense.
Good morning, Your Honor. Joseph Archambault Rose Roy, Officer of the Colorado State Public Defender, on behalf of Mix Aldrich, who appears in custody to my right.
Good morning. Do the people have charges to file in this case?
Yes, Your Honor. And we electronically filed this morning, but in the abundance of caution, we also have paper copies. We provided a paper copy to defense. I have a paper copy for the court as well.
Thank you.
Filing 305 total charges. Counts and theories of murder in the first degree, attempted murder in the first degree, assault in the first degree, assault in the second degree, and many counts of bias-motivated crimes. And then the attendant COV charges, crime of violence charges as well.
All right. Does the defense waive any further reading or advisement on these charges?
We do, Your Honor.
Now, the defense has already requested a preliminary hearing. Should we be scheduling that hearing today?
Your Honor, speaking to Mr. Allen, that was our hope, is to find a date that works on the court's calendar. The court staff had given us some potential dates. We had explained to the prosecution, and Mr. Allen shared with me that we have a lot of obligations already, both of us, that are going to make it difficult to get something scheduled in early spring. So the defense request would be to accept the dates that the court staff had offered us. I think it's May 31st, June 1st, June 2nd.
What are the people's thoughts about the defense suggestion as to timing of the preliminary hearing?
Judge, obviously, to set something out beyond the 35 days, we would need a waiver from defense to go beyond that 35-day requirement. We are also requesting that this is a proof evident presumption grade as well as a preliminary hearing. If the defense makes that appropriate waiver, I think we can look at scheduling out further. I can tell the court, and I think defense has already signaled this to the court as well, that this case we expect to be very voluminous. It will probably take some time for defense to digest it and be ready for presentation of evidence at a preliminary hearing / proof evident presumption grade. So it seems to make sense giving a proper waiver to set this out to some degree into the future. Obviously, we've talked to the court offline and looked at some dates, which I think would be appropriate.
It is my preference that the defense receive the discovery in time to make meaningful use of it prior to the preliminary hearing. The date that my staff suggested to counsel was in February. How confident are the people that the core of the discovery could be provided to the defense in enough time for them to make reasonable use of that by that February date?
So there will be, obviously, this case is going to be, continue to be investigated for quite some time, I would suspect. I should also say in relation to that, that it's somewhat likely that we will amend charges to add or maybe even subtract, depending on, as we identify potentially more victims in this case that we have not identified to this date. I think a big chunk of it should be available to them. I just don't know what their work schedule will allow them to digest before that February date. And I think that's what defense is signaling, is that they may not be able to really make meaningful use of discovery by that February date.
The defense's suggestion of a May date strikes me as much longer than the usual period of time that we would delay a preliminary hearing in a case like this. What's the people's thoughts about their suggestion?
So part of, I think, what gets us out that far, Judge, is just our respective schedules. I can tell the court that I've got a 6-week trial scheduled on the Letitia Stout case that is scheduled to start on March 17th. And again, will be jury selection, and then we'll start presentation of evidence the following Monday. And again, we're scheduled for a 6-week trial on that case. I think because of the challenges that I have specifically, and then I think defense also has some lengthy trials in the interim, I think that's the reason why they were potentially looking at pushing it out that far. Obviously, we'll defer to the court as to ultimate scheduling, but I think those are the scheduling challenges that we're all dealing with.
How many days do you believe the preliminary hearing and the proof evident presumption great hearing will take?
Judge, I think that we can present our evidence at that hearing in 2 days.
Mr. Archambault, your estimation of the length of this hearing?
Your Honor, I have no idea, given on how little discovery of the total volume we've received, given that we just got the complaint. They did file it a little ahead of time today, but we haven't even been able to really digest it in any meaningful way.
Have you received any discovery yet?
We started receiving discovery on Friday, and we've been starting to try to read it and review it in media. It's ongoing how we're receiving it, and I believe it will be for some time.
I don't believe my staff ever received a response from you about whether those February dates you are available.
Your Honor, Mr. Bowman obviously isn't here with me. We would not be ready to proceed to a preliminary hearing on those February dates due to some obligations we have for other clients and other cases that we have to be either in or preparing to do. I myself have a trial that starts early March. That's a 4-week trial, homicide trial that I have, and some other important preliminary hearings and some other homicides in February.
I appreciate your argument, but I'm not convinced. I'm going to go ahead and schedule this proof evident presumption great hearing on those dates in February that my staff provided to you. I believe we can do this hearing in 2 days, and I'm familiar with how your office generally litigates this type of case, and I'm certain that they have the resources to make sure that you're available on that date. And so from my staff, that date in February again was February 22nd through the 24th.
Starting at 8:30 in the morning or 9, Judge?
Starting at 8:30.
Your Honor, I guess I just have to make it clear for the record, we are objecting the court setting the preliminary hearing over Ms. Aldrich's objection, and we're doing so under Ex Rel Farina 522 P. 2nd 589 at 591 Colorado Supreme Court 1974. And we believe that we are not going to be ready. We will not be effective on that date. And we think that that is why we are objecting, Your Honor.
Understood. As you receive discovery and you're able to form concrete opinions about what it is you need to do in preparation for that hearing, I will entertain future motions on this subject.
And Judge, just for record purposes, we still do need a waiver to get even out to that February trials, or I'm sorry, proof evident presumption great prelim hearing date.
Your Honor, we have discussed that. Ms. Aldrich has no objection to that, waives 35 days. I don't know if the court needs that in writing, but We've discussed that in detail, no objection, we're waiving that.
I'll accept the 35-day waiver. Before we terminate the recordable portion of the proceeding, is there anything else either side has regarding the filing of charges?
Not from us, Judge.
Not for the defense, Your Honor.
As the attorneys know, there's a standard protection order related to the victims in the case that will enter as of this moment right now. We will need the defense to sign that before he leaves this morning, and so you'll need to be involved with that with my staff. This concludes the recordable portion of this morning's hearing, and the media is ordered to cease any recording or live streaming at this time.